Hi girls, we have been seeing this topic, different types of customers and account holders. A few of the customers and account holders we have seen in detail. Now to continue with the same topic, we will see the next type of customer or account holder. So that is going to be executors and administrators. Now as far as these topics are concerned, like these subheadings are concerned, so I want you all to do one thing, that is you'll only cover up with what is the meaning of the executor or administrator, and then straight away you can go to what are the precautions that a banker needs to take with regards to the account operation of these kind of customers. Okay, so till the previous topic we have even seen what is the nature of such kind of a concern, right? So public limited, joint stock company, all that we have seen that even the nature of such kind of concerns was seen. So here you can stick to only the meaning of each of these terms, and then you can go ahead covering up the precautions that the banker needs to take. All right, so firstly let's see who is this executor and administrator. Before we see in detail administrator, let's see who is an executor. Now executor is none other than the one who executes the will of an individual. Okay, so it's common for people to write wills. So I think you have heard of people saying that I have written a will and that will be executed after my death and things like that. So when people have a lot of property and that is to be made over to their descendants, and if they have any discretion with regards to the same, okay, they will write it up in the form of a will. Alright, that is, this particular property belongs to this person, and like for example, if a person has more than 2 children or more than 1 child, then they obviously discreet and say that all these property belongs to this particular child, and then the other properties belong to the other child. So like this they write up a will. So but also remember that you will be able to write up a will only when the property is earned by yourself. So any individual who earns the property by himself, okay, only then he'll be allowed to write a will. Now supposing if it's an ancestral property, that which it's passed on from generation to generation, so that is something which you cannot write up a will for. Okay, so it's understood that whatever property belonged to the grandfather is passed on to the father now, and next it will obviously be passed on to the grandchildren. Okay, and it will just continue from one generation to another generation. But any asset that you are earning by yourself with your hard-earned efforts and things like that, then you are allowed to write up a will for the same. Alright, fine. So coming back to this testator. Testator is someone who writes the will, girls. So these testators are someone who will appoint an executor, okay, to execute the wills that they have written. Alright, so these executors becomes the representatives of the testators, and they try to execute the wills that has been written by these testators. And this is most of the times done in the event of the death of a person. Okay, and here in this context, as we've been seeing all about banks also act as executors. So they also execute the wills of individuals. So given standing instruction, also given a will to safeguard and to execute the same, it would be done as it is by the bankers. Alright, now we will see who is an administrator. So you can stick to the meaning, girls, and that is enough. Now the next thing that we will see is an administrator. Who is an administrator? So when a person dies without writing a will as such, and is left over with a lot of property, then the court of law will declare a person to be an administrator. Okay, so he can administer the assets, or he can administer the business, that which is left back by a deceased person. When you call anybody deceased is when that person dies. Okay, so sometimes life is very uncertain, isn't it? So you know not what would happen, and such young people die in such young age as well. So at such instances where they never even expected death, and if suddenly this has happened, and usually you see old people only writing up wills and keeping, where they know that they won't be for too long. Obviously people are all not immortals, isn't it? So that way they would write up the wills only when they are like getting older. most of the times it's not done in earlier stages of life. So at such instances where a will is not written at all, okay, so at that time the court of law will interfere and will appoint a person to administer over the assets, administer over the business and things like that. So who are these preferred people who are chosen by the court of law? None other than a spouse. Okay, for example, if the husband dies, the wife will become the administrator. In case the wife dies, the husband will become the administrator. And also the children, the parents, siblings, cousins. So like this, most of the time the court of law chooses somebody from within the family to administer. Okay, and there are instances also where third parties can be appointed, but most of the times it's not done so. Did you understand? So that is who is called as an administrator. So basically, in the absence of any will written, the court of law will declare a person to administer, to take charge and kind of like take care of the properties and or run the business whichever is left behind and things like that. So this is about administrator. Alright, so now we will see the precautions that has to be taken by the banker with regards to the executors as well as the administrators. Okay, so it's common for both executors as well as administrators. So here the first precaution that the banker must take is the banker must go through the probate of the will. Okay, so all the terms and conditions of the will as an executor. And he should also obtain the copy of that particular will and he should keep it back with him. Okay, so not only he must go through, he must get the knowledge of what is being written as a will by the testator, but the banker must also take a copy of the same. Okay, then the next thing would be the banker must be careful to ensure that there is no misappropriation. So you should also not misappropriate the funds. Okay, should not make any wrongful usage of the funds. Do you understand? And transfer it to personal accounts and things like that. All followed. Then not just that, he also, the third point, he should also see to it that is if an administrator or executor dies. Okay, so if the administrator or executor dies, obviously there immediately the checks which were written earlier will not be honored. Okay, it will be dishonored. But supposing if there are more than one administrator or executor, see if there is only one executor and administrator, then if already the person is deceased and he is taking care of the property of somebody else and he has every right to sign and sign the checks and take care and do everything. Now supposing the person dies, whatever checks which were signed by him will immediately be dishonored. But in case there are joint signatories, meaning there are more than one executor, more than one administrator, if one administrator and executor dies, obviously the powers will be in the hands of the other executor or administrator who is still alive. Do you understand? So this is where you have more than one executor. Please understand that. The surviving executor will be allowed to administer. Okay. Then next one, the banker cannot exercise their rights to set off the deceased's debit account with that of the executor's personal account. Okay, meaning obviously the banker is given some kind of a responsibility to either be an administrator or a executor. In such a case, he will be handed over all the assets, okay, in his hand of the deceased person, that is the person who has died. Now in that case, this particular executor or administrator cannot use the assets of that deceased person to make good some losses that he has suffered, or to trying to bring some kind of balance between his credit balance and the debit balance of the deceased person. Okay, so that's why it's already told that he's not supposed to misappropriate, isn't it? He cannot use any of the funds for his own personal use, right? So that way it should not be mixed with the account of the executor and the account of the deceased person. Right. Next one. After the probate is granted, the executor may pledge the specific assets to obtain some kind of overdraft facilities. Supposing if the probate, that is the rules and regulations, the bylaws, whatever referred in that particular will, grants the permission for the administrator or for the testator to use the assets, it can be used. If there is no permission given, then it cannot be used. For example, now I told you in case of administrator that if the husband dies, the wife can be the administrator, take care of everything. So obviously now everything will belong to the wife. So the wife will have every right to pledge over the property, or to take a loan on behalf of that property and things like that. So in such case it's allowed, provided it's also made a mention. And most of the times what happens is it goes without saying when it comes to the spouse or the children, the descendants, but it has to be told and it has to be mentioned in the probate if it is going to be a third party who is going to manage or administer or execute the documents and the wills of an individual. So that you have to keep in mind, right? Apart from that, if a loan is given, all the executors should sign the documents. So if there is more than one executor and if a loan is given, then all the executors should sign. Alright, so that is about the precautions to be taken by the banker with regards to the administrator and the executors. Alright girls. Now we will see the next topic. That is the next subheading, trustee. Okay. So trustee is also another type of a account holder. So let's see who a trustee is and what are those precautions that a banker is supposed to take with regards to a trustee. Okay. And how is the banker going to manage his account? So firstly, who is a trustee? The trustee is none other than an individual person. Okay. It not necessarily is one person. It could even be members of the board. Okay. Who are given some kind of control. Meaning to say a trustee need not be one individual person. It can even be group of individuals. Alright. So they are given some kind of control or powers of administration. Okay. Of property in trust with the legal obligation to administer it solely for the purpose of, for whatever purposes that which is specified. Okay. So you can take the example of churches, mosques, temples, where people, come together and they work for that particular trust or organization, and they also become the trust members who are given some kind of authority in hands. Now, this trustee, okay, is basically a legal term, okay, which is given to someone who holds a property on behalf of a beneficiary. Alright, so they are just holding the property on behalf of a beneficiary for whomever they are working for, whether the church or mosque, whatever they are working for, they are working for the benefit of that particular organization. So they are called as trustees. Do you understand? So here trustees have some duties that which they have to execute. So to make a mention of few of the duties of the trustees is, first thing is, whatever be the terms and conditions of the contract between the trustee and the beneficiary, that has to be kept in mind by the trustee. Okay, so whatever is being the power, whatever is being the do or don't of the trustee should be the trustee should be following all that. And not just that, also he should see to it that he always is working to the interest of that particular beneficiary. Alright, so he must see that he is working for the welfare of that particular beneficiary. He shouldn't be partial. He should be impartial among all the members of that particular organization who are the beneficiaries. And then they need to be, doing everything that which is delegated to them. Whatever work is being given to them, that has to be done by these trustees. And not just that, they also should not be profit-minded. They should never work to be benefited from that particular trust. They are someone who will voluntarily come up to provide some sort of services where they most of the times are not going to avail any benefits that from that particular trust. Do you understand? Rather, they should be profit minded. They should instead be service minded. And they shouldn't involve any kind of conflicts and things like that. So most of the times they should work for the benefit of the beneficiaries. Do you understand? So those are certain duties which like goes without saying once a person becomes a trustee. Now let's see the precautions that a banker needs to take with regards to a trustee. So first thing that he has to do is before he opens a trust account, the banker should make sure that he is examining the original trust deed. Okay, the original trust deed should be completely examined and you should find out the nature of that particular trust. Also, you should go through the names of all the trustees and what is the power that which is given it to them, okay, with regards to the property. So all that the trustee should go through and analyze, right? The next important precaution that the trustee should take up is the trustee should obtain a duly certified copy of the trust deed, okay, for any kind of future references. So all these documents, the deeds that which is made, should be it should be handed over, or a copy of that should be duly be obtained by the banker for any kind of references with regards to the trust. The next one, the banker should also obtain a certified copy of the resolution that which is passed. Now, every time there is a meeting, there will be some new resolutions that's being passed, isn't it? So all that should be brought to the notice of the banker and it should be given as a certified copy. And opening of an account with the bank, the names of the trustees, everything should be like literally given in that particular certified copy, right? Then the next precaution is the banker should get the account opening form duly signed by the trustee authority. Okay, though there might be a lot of people who are working for the trust, still the trustee authorities are the only one who are allowed to operate the account. Do you understand? So this account opening form should be duly signed by such kind of authorized trustees. Next one, the banker should also obtain a declaration from all the trustees, okay, that they are willing to act as trustees as per whatever is the terms, the conditions that which is laid down, okay, in the trust deed. What is a trust deed? So deed is nothing but again a contractual document which will have all the rules and regulations relevant to that particular trust. What can be done, what cannot be done, what are the do's, don'ts and things like that. So all that needs to be looked into, okay, right. Then the banker should open an account in the name of the trust and obtain specimen signatures of the trustees. So though the trustees are only operating, still on whose name the account will be opened, the trust's name, okay, but the signatories will be a few of them who are authorized to do so, and such signatures also should be taken as a specimen so that they would refer as checks are presented or any financial instruments are passed with the bank. So that's about the precautions to be taken by the banker with regards to the trustee. Okay. So I'll be sending another video with 2 more subheading skulls. If at all you did not understand anything, please revert back to me for clarifications. Thank you.